Hello students, my name is Amna Zaman and I'm your lecturer for criminal law at LGS International Degree Program. Our topic for today's discussion is non-fatal offenses against the person. This is chapter 9 of your study guide. Non-fatal offenses primarily are crimes against persons that do not involve a killing. Our aim for today's lecture would be to study the hierarchy of such crimes, ranging from the most serious ones to the least serious ones. The aims for today's lecture would be to understand what are crimes of violence, what are crimes against autonomy, points of difference and points of comparison between Section 18, Section 20, and Section 47 of the Offences Against the Persons Act. We will also try to understand the difference between assault and battery and the role that consent plays in non-fatal offenses against the person. Before we start, you need to understand that broadly speaking, there are two types of crimes. The first category is crimes of violence, and the second category is crimes against autonomy. When we talk about crimes of violence, we'd be talking about primarily three offenses. The offense set out in Section 18 of the Offences Against the Persons Act, the offense set out in Section 20, and Section 47 of Offences Against the Persons Act. After having considered these three offenses, as you can see in the pyramid right in front of you, we will then move on to crimes against autonomy. And in crimes against autonomy, we will be talking about assault and battery. The crimes of violence are set out in the Offences Against the Person Act 1861. And the most serious of these crimes of violence is the Section 18 offense. The Section 18 offense basically says that any person who unlawfully or maliciously by any means wounds or causes any grievous bodily harm to another person with the intent to do some bodily harm or with the intent to resist or prevent arrest shall be charged under the section. Now, Section 18 has two essential elements that need to be fulfilled before the prosecution can bring a successful charge against a person in the section. The first element is the actus reus element, and the second element is the mens rea element. The actus reus element requires that there should either be a wounding or grievous bodily harm. So you need to prove that the defendant either wounded the victim or the defendant caused grievous bodily harm to the victim. Any one of the two elements would have to be proved. With the actus reus, the prosecution will now have to prove the mens rea. And the mens rea for Section 18 is specific intent. Section 18 is a crime of ulterior intent, which means that with the actus reus, the defendant should be having an intention to cause grievous bodily harm or an intention to prevent arrest. If this cannot be proved, successful conviction under this section won't be possible. Now, before we move on to the mens rea element, it is very important for you to understand what actually do we mean when we say that the defendant either has to cause a wound or has to inflict grievous bodily harm. When we talk about wound in legal language, wound requires a penetration of both layers of the skin, dermis and the epidermis. This means that if there is a cut, which has to amount to a wound for the purposes of Section 18 Offences Against the Person Act, there has to be a break in the two layers of skin, and the two layers of skin are dermis and the epidermis. Internal ruptures or wounds that do not involve a penetration of two layers of skin, bruises, they do not amount to a wound. The second element of the actus reus for Section 18 is grievous bodily harm. Grievous bodily harm has been defined by the court in a number of cases. However, it is still believed that the definition for grievous bodily harm in the case law is a bit confusing. For instance, in 1961, in the authority of DPP against Smith, the court defined grievous bodily harm as really serious bodily harm or injury. Now, this was not a very helpful definition. However, in 1999, another attempt was made to define grievous bodily harm in the authority of Chanjol. In this, the Court of Appeals said that grievous bodily harm means serious harm. This was once again not a very clear definition of what would amount to grievous bodily harm. In 2003, the authority of Bolam seemed to give some more explanation as to what factors the court is supposed to consider when taking into account the fact whether the act is serious for Section 18 has been committed or not. In this case, the court said that in deciding whether harm was serious or not, the jury should take into account three main factors. And those three main factors were the age, the state of physical fitness of the victim, and the extent and nature of the injury. So if the victim is, let's say, a baby who's really fragile, or someone who's really old and they have more chances of being hurt as compared to a very strong young person, then that will be taken into account. Moreover, what was the nature of the injury? That is also a factor which would be decisive when the jury has to give a verdict on whether the Section 18 offence can be charged or not. However, something which proved to be a bit more helpful when deciding whether grievous bodily harm has occurred or not were the guidelines given by Crown Prosecution Service. So basically, they provided a few examples of situations that, if occurred, would amount to grievous bodily harm, and therefore a conviction for Section 18 can be secured if the mens rea is available as well. These factors included serious wounds, breaking an arm or leg, savage beatings, knocking someone unconscious for more than a brief period of time, injuries that involved permanent disfigurement or long-term treatment, or injuries that involved serious loss of blood or required a surgery. An interesting thing noticed was the fact that the guidelines said that grievous bodily harm would also include sexually transmitted diseases. And this was confirmed in 2004 by the authority of TICA. In Burstone in 1997, the court further confirmed that serious psychiatric illness or serious psychiatric injury would also amount to grievous bodily harm. Having considered the actus reus of Section 18 and having considered in detail what amounts to a wound and what amounts to grievous bodily harm, it is important for us to understand that with the actus reus, the prosecution will have to prove that the defendant had the required mens rea, which is the specific intent to either resist arrest or to cause grievous bodily harm to the victim. Nothing else would suffice. However, if the prosecution finds it hard to prove specific intent, then an alternative offence that can be charged is the Section 20 offence. Section 20 of the Offences Against the Persons Act, which is about malicious wounding or inflicting grievous bodily harm, says, whosoever unlawfully and maliciously wounds or inflicts any grievous bodily harm against any other person, either with or without a weapon, shall be guilty of an offence and shall be liable to imprisonment for not more than 5 years. Now, what is the difference between Section 18 and Section 20? And what are the similarities between these two crimes of violence? Let's start with the similarities. The biggest similarity between Section 18 and Section 20 of the Offences Against the Person Act, both of which are crimes of violence, is the actus reus of the offences. For both the offences, the actus reus comprises of two elements. First, there has to be a wounding, or second, there has to be infliction of grievous bodily harm. So this brings us to the point of similarity between Section 18 and Section 20. Since we have already discussed in detail what amounts to a wound and what amounts to grievous bodily harm, we now need to understand that the legal definition of a wound and grievous bodily harm is the same as we considered in Section 18. So the actus reus for Section 18 and Section 20 is the same. The question then remains, what is the point of difference? Why are these two different separate offences in the statute itself? There has to be some difference. The difference is the mens rea requirement. Unlike Section 18, that requires specific intent and which is a crime of ulterior intent, the mens rea for Section 20 is subjective recklessness. In the authority of Mowat in 1968, the Court of Appeal ruled that it is essential to prove that the victim, the defendant, either intended or foresaw harm befalling the victim. So there can be intention or there can be recklessness. When I say recklessness, it means that the prosecution would not have to prove that the defendant specifically intended to cause grievous bodily harm to the victim. The prosecution would only have to prove that the defendant was reckless, which means that the defendant was running a deliberate, unjustified risk of which the defendant was aware. Once the prosecution can successfully prove that the defendant was reckless as to the fact that the victim might be injured, it is not necessary to prove that the extent of harm was foreseen. This was set out in Parmenter. In Parmenter, the House of Lords clearly said that the defendant cannot then argue that he did not foresee the degree of harm. The fact that some harm could be foreseen was enough for the prosecution to get the defendant successfully convicted under Section 20 of the Offences Against the Persons Act. Another very important aspect of Section 20 was the infliction and causation debate. The statute clearly says, as you can read right in front of you, whosoever shall unlawfully and maliciously wound or inflict. Initially, it was thought infliction is different from causation, and inflicting means to be actually applying force directly to the victim's body. So there has to be a face-to-face contact, or there has to be a face-to-face encounter between the defendant and the victim. This was a misunderstanding for a very long time, and in a very famous authority, Clarence, the defendant was not convicted after transmitting a sexual disease to his partner because the intercourse was consensual. And when there is consent, there is no infliction of harm. It was only in the case of Wilson that the court very clearly expressed that infliction is same as causation. So you can inflict harm in two ways, either by way of an assault, which was always understood by direct attack. And the second way of inflicting harm was by doing something intentionally, which although itself was not a direct application of force to the body of the victim, but it directly results in force being applied violently to the body of the victim. And that thing done, which resulted in direct force being applied to the victim's body, was intentional. Now I will give you two examples for you to be able to understand the difference between causing harm and inflicting harm. So when I say that infliction by assault or direct application of force, an example of it would be the defendant punching the victim. So if the defendant punches the defendant directly applies force to the victim's body. However, if I say that infliction was done by something which resulted in force being applied to the victim's body, even though there was no assault. An example to illustrate this point would be to think of a defendant who digs a pit, knowing that the victim would be passing that way. And while the victim passes, he falls into the pit and gets his legs fractured. Now, in this situation, the victim was not assaulted by the defendant, but however, the defendant did something intentionally by digging the pit, which resulted in direct force being applied to the victim's body when the victim fell into the pit. So, this is the difference between two ways in which you can inflict harm. And inflicting after Wilson is now same as causing. The same principle was confirmed in a few very important authorities that included Halliday, Burstow, and Ireland. In these cases, the court clearly said on the facts that there is no need for the victim to be attacked by the defendant, as long as the defendant does anything whatsoever that results in force being applied to the victim's body. We will now move on to our third crime of violence, which is set out in Section 47 of the Offences Against the Persons Act. This third crime of violence is assault occasioning actual bodily harm. Now, Section 47 clearly says that if a person commits assault that results in bodily harm, he would be convicted under Section 47. Now, there are three essential requirements that the prosecution will need to fulfill if the prosecution wants to get the defendant convicted under this section. The first element is common assault. And when I say common assault, I mean assault or battery, either threatening the victim in a way that the victim apprehends force or applying direct force to the victim's body. So causing apprehension of force or applying force to the victim's body both amount to common assault. And if this common assault causes actual bodily harm to the victim, then a claim under Section 14 of Offences Against the Person Act exists. However, the third requirement after actual bodily harm is a causal connection, which means the prosecution will have to prove that the common assault caused actual bodily harm. Now, what is actual bodily harm? We've just talked about previous bodily harm, and we discussed that previous bodily harm means that you are causing really serious harm to the victim. Actual bodily harm has to be something of a less serious nature, obviously, because we are talking about these crimes in terms of their seriousness. Section 18 being the most serious offense, Section 20 is lower in hierarchy than Section 18, and Section 14 is the it's the least serious crime of violence set out in the Offences Against the Person Act. Actual bodily harm was defined in the authority of Donovan, 1934. In Donovan, the court said that any hurt or any injury which interferes with the health or comfort of the victim, provided it's of a substantial nature and nothing trivial, will amount to actual bodily harm. So this basically means that we are not talking about grievous bodily harm or a very serious injury. Neither are we talking about a scratch or a bruise or something of a non-serious or trivial nature. It's something in between. So actual bodily harm, after the definition set out in Donovan, is any injury or hurt which interferes with the health or comfort and is of a substantial nature. A very interesting aspect about actual bodily harm was observed in the decision set out in the case of DPP against Smith 2006. In this case, the defendant cut the ponytail of the victim and it amounted to actual bodily harm. And the court said that cutting the woman's ponytail was battery because force was being applied to a part of her body. And the fact that it was actually cut amounted to actual bodily harm. And for actual bodily harm, there is no need to prove that a living tissue was damaged. So be it your hair or your nails or any dead tissue. If that is damaged, it amounts to actual bodily harm. This is a very interesting observation about what amounts to actual bodily harm, and this should be kept in mind when answering problem questions. Apart from that, the court highlighted in the Authority of Shanfook in 1994 that psychiatric injury can also amount to actual bodily harm. So like in the guidelines we just went through for grievous bodily harm that said that serious psychiatric injury would amount to grievous bodily harm. If the psychiatric injury is not very serious, it can amount to actual bodily harm. However, the court clarified that shock, pain, panic would not amount to actual bodily harm either. There has to be a recognized psychiatric illness. If there isn't a recognized psychiatric illness, there won't be a conviction under Section 47 because the prosecution would not have proved that the act is serious for the offense has been committed. In Ireland and Bristow, both of the cases, the court highlighted that even if the defendant gives a silent telephone call to the victim, that can amount to common assault if it results in psychiatric injury. So on the facts of these cases, the defendants were stalking the victims. One of the defendants stole clothes from the victim's laundry line and things like those. So they were sort of, trying to harass the victims. And in both of the cases, although there was no face-to-face confrontation between the defendant and the victim, it still amounted to common assault. Now the third requirement, since we've already talked about what is common assault, we've talked about what amounts to actual bodily harm. The third requirement for securing a conviction under Section 47 is that the prosecution must prove that an unbroken causal chain linking the victim's injury with the defendant's assault exists. Causation, as we've already studied, involves factual causation and legal causation. So the prosecution would now have to prove that both factual and legal causation exist. It is only then that they would be able to get the defendant convicted under Section 47. So just the fact that there was common assault and the fact that the common assault with common assault there was actual bodily harm is not enough. You would have to prove that the assault caused the actual bodily harm or the assault resulted in actual bodily harm. This now takes us to the second part of the chapter, that is crimes against autonomy. Crimes against autonomy comprise of two offenses: assault and battery. Now let's discuss the actus reus and mens rea for both of these offenses. Before we start talking about the actus reus and mens rea of crimes against autonomy, I want to remind you that the crimes of violence, they are more serious crimes than crimes against autonomy. And one very important aspect of the crimes of violence is that there has to be proof of harm. But for crimes against autonomy, there has to be no proof of harm. The second important aspect about these two crimes is, for crimes of violence, consent will never be a defense. However, for crimes against autonomy, the victim's consent will in itself be a defense. So absence of consent is an essential element for crimes against autonomy. Let's start with assault. The actus reus for assault is causing the victim to apprehend infliction of immediate unlawful force. So anything that you do which results in the victim apprehending unlawful force on their body is assault. The mens rea requires either an intention to cause apprehension of unlawful apprehension of infliction of unlawful force, or recklessness as to whether an other person fears immediate unlawful force on their body. Whereas for battery, the actus reus is actual infliction of force on the body, and the mens rea is intention or recklessness as to the fact that actual force is inflicted on the victim's body. Now, this is where you need to understand the difference. Assault means you are threatening somebody with the intention to threaten them, or you're just careless, you're just reckless about it. Whereas battery is actually applying force to the body of the victim with the intention of applying force on the body of the victim, or because the defendant was reckless as to the fact that force could be applied to the victim's body. Now, assault and battery are offenses in their own right. However, they can also be ingredients in other offenses. For instance, Section 47 offense that we just discussed. Section 47 offense requires assault occasioning to actual bodily harm, which means that you will have to prove assault and actual bodily harm. So in Section 47, assault is an ingredient of the bigger offense. But assault and battery are offenses in their own right as well. Let's have a detailed discussion on what amounts to assault. What is the actus reus of assault? Like I just discussed, the actus reus involves acting in a manner that causes the victim to apprehend immediate unlawful contact or force. Immediacy is a very important element. In the beginning, immediacy was central to the offense. That was the reason in Thomas against MUN why the court decided to not convict the defendants of assault, because the defendants were in a position that they could not have brought their threatening gestures into action, because the victims were basically guarded by the police. Since the requirement of immediacy was not fulfilled, which means that the defendants could not have immediately inflicted violence and could not have carried out the threatening gestures they were making to the victims, the conviction could not be secured. However, in the recent years, this requirement of immediacy has been relaxed. Now the court clearly seems to have understood that it is not the reasonableness of the victim's fear. What matters is the effect of the threat on the victim. So, for instance, if you're standing at a distance from the defendant and the defendant gives you a threatening gesture, and you're afraid and you apprehend unlawful force, the reasonableness of your fear will not be assessed. And the fact that the defendant is in a situation or in a setup where he cannot immediately inflict force on you should not be a reason why the defendant is not convicted. This was seen in the case of Smith against Chief Constable of Woking. On the facts of this case, the defendant was standing outside the victim's window and staring at her. Although he was outside the apartment and he could not have entered immediately and harmed the victim, but he was still convicted of assault, of committing assault. Why? Because the court said that immediacy was no longer a requirement. And by standing outside the window and by staring at the victim, the defendant actually instilled fear of violence in the victim. And that should be enough because the victim apprehended unlawful force. In 1997, the authority of Constanza further clarified that threatening letters to the victim from the defendant could also be an assault. Now, when somebody is sending you a threatening letter, they're you're not expecting a situation where they're in front of you, so you get a threatening letter, and that results, let's say, in psychiatric harm. That still can be an offense under section 47, or it could be assault if it doesn't even amount to any harm, because crimes against autonomy do not require proof of harm. So my point here is that even if the defendant did something that provoked fear of violence at some time, not excluding the immediate future, the defendant can be convicted. So the requirement of immediacy has now been relaxed. And we should now understand that immediate has been, in a way, replaced by the word imminent. So if there's no immediate danger or of the force being actually applied to the victim's body, the fact that it is imminent should suffice. This takes us to the mens rea requirement for common assault. The mens rea requirement involves either an intention or recklessness, which is foresight, deliberate running of an unjustified risk of which you're aware. So you were either intending to assault the victim, or you were reckless as to the fact that your act might result in causing the victim to apprehend unlawful force. Please have a look at the authority of spread, because it would further clarify your concept. We will now discuss the second crime against autonomy, which is battery. The actus reus for battery is application of unlawful force to the victim's body. So over here, you won't have to disprove that the defendant threatened the victim to an extent that the victim apprehended unlawful force. There has to be actual force applied on the victim's body. And there's no need for the prosecution to prove that the force that was applied to the victim's body was painful or hurtful. There has to be some force. Because this is not a crime of violence, it's a crime against autonomy, which means that there's interference with the person of the victim, something that the victim did not allow, the victim would not have consented to. So for instance, spitting on the victim, throwing water on them, cutting their clothes while they're still on their person, or kissing them without their consent. All of this would amount to battery, because in one way or the other, force has been applied to the victim's body. And for crimes against autonomy, we do not need proof of harm. A very important aspect about the crime of battery is that the battery as an offense cannot be committed by an omission. There has to be an act. An exception to this is the continuing act doctrine set out in Fagan against MPC, in which the defendant reversed the car and parked it on the inspector's foot unintentionally. When the inspector told him to remove the car, the defendant decided to not remove the car, and that was the time when he formed the mens rea for battery. When he was sued, his argument was that he omitted to act, which means he omitted to remove the car from the officer's foot. So omission cannot amount to a battery. The court rejected the argument, and the court said that his act of not removing the car will not be construed as an omission, but it would rather be considered as a continuing act. And then mens rea was later, mens rea later existed, and the combination of the two, actus reus and mens rea, amounted to battery. So the continuing act doctrine seems to be an exception to the fact that a battery requires an act. Because in such cases, the court is not prepared to consider your failure to act as an omission, but the courts would rather think of it as a continuing act. Apart from that, a couple of very interesting authorities have clarified that it is not necessary for there to be direct contact between the defendant and the victim. which means that battery can be committed indirectly. Let's discuss a few important authorities. In Scott against Shepherd, 1773, the defendant threw a firework in a crowded marketplace. It passed a couple of people, and finally, when it got to the victim, it exploded in the victim's face. The defendant's argument was that he did not directly throw the firework at the victim, and there were a few people in the chain who got hold of the firework, were afraid, and threw it away. So the last person who threw it to the victim should be convicted because there is no direct link between the defendant and the victim. The court rejected this argument, and the court said that there needs to be no direct contact between the defendant and the victim, and battery can be committed indirectly. So was the case in DPP against K.A. Minor, 1990, in which the defendant poured an acid into the hand dryer, and all the students in the school who used the hand dryer had burns on their hands. Now over here, the defendant did not directly throw acid on the victim, but indirect battery was committed, and the defendant was convicted. So battery can be indirect. Another important requirement for battery is the fact that the force or the threat of force, so be it assault or battery, be it is even if there's application of force or there's a threat of force, it has to be unlawful. And there are certain situations where the application of force or threat of force will not be unlawful. For instance, if the defendant is acting in self-defense, or for crimes against autonomy, the contact is consented to. In such situations, there will be no unlawful force. Let's take example of a lawful arrest. In all of these cases, the court seems to have taken the stance that the force, the application of force, or the threat of force for common assault has to be unlawful. Two very important authorities on the matter are Kenlin against Gardiner and Donnelly against Chapman. In Kenlin against Gardiner, the defendant acted in self-defense when the police tried to get hold of him unlawfully. Since the police was acting unlawfully and the defendant acted in self-defense, the court said that the force applied by the defendant in beating the police officer was not unlawful because the defendant was trying to defend himself. If you contrast it with the facts of Donnelly against Chapman, in this case, the force applied by the police by tapping the victim's shoulder and stopping them for investigation was not unlawful. So the victim's response by punching the police officer was an unlawful response and was not a valid act of self-defense. So battery was committed. This now takes us to the mens rea for the offense of battery. The mens rea requirement says that there has to be intention or recklessness as to the application of unlawful force to the victim's body. There is no need to intend the resulting harm. There is no need to know the degree of harm. In fact, there is no need of harm for there to be a conviction under battery or assault, because crimes against autonomy, I repeat, do not require proof of harm. We will now move to the third part of our chapter, which is a very interesting and important part of the chapter: consent. The rule of thumb is absence of consent is an essential element of crimes against autonomy. So if it's crime against autonomy, consent will always be a defense. However, if it's a crime of violence, consent will never be a defense. However, even for crimes against autonomy, where you tend to consent to, let's say, water being thrown at you or somebody giving you a slight push, or that which is normal between friends, the consent has to be effective. And the consent will not be effective if the victim lacks capacity, let's say because of age. So if there is a lack of mental capacity, then there will be no consent. This was seen in the authority of Burrell against Harmer, in which the defendant carved tattoos on two teenagers and with their consent. When the defendant was convicted, his argument was that the victims consented. The court rejected this argument, and the court said that their consent was not effective because they lacked the capacity to consent. Another important aspect is the element of fraud. If the consent is secured with fraud, fraud would vitiate consent, provided the fraud is as to the nature and identity of the act. Nature of the act and identity of the person. Examples on the matter are Bodek against Bird and Richardson. In both the cases, the defendants were not convicted because the deception was not as to the nature or identity of the act. It was rather the quality of the act. So, for instance, in Richardson, the victim went to a dentist for a dental treatment and later found out that his license had been cancelled. So, the victim sued the dentist and said that my consent was obtained fraudulently because I did not know that the victim had been struck off. This was not available, and the defendant was not charged because the court said that the deception or the fraud in this case was as to the quality of the service provided, but the nature of the act was exactly what the victim wanted. She wanted a dental treatment, she got a dental treatment. She wanted it from a dentist, it was a dentist. The fact that he was not a licensed one and his license had been cancelled was a matter that had a bearing on the quality. However, we need to contrast the facts of this case with the facts of the Tabassum in 2000. In the case of the Tabassum, the victim went for a medical examination of her breast and she was sexually harassed. Now, on the facts of this case, the consent obtained vitiated because of fraud, and this was because she had been deceived as to the nature of the act. She wanted medical examination, and what she got was sexual assault. In Dika and Kanzani, the court clearly said that consent to the act of intercourse will be vitiated for the purposes of sections 47 and section 20 if unknown to the victim but known to the defendant is suffering from a sexually transmitted disease. So if the defendant suffers from an STD and the defendant know that they have a sexually transmitted disease and they do not tell the victim about it and the victim consents to intercourse, this won't be consent. Why not? Because the victim was not aware of their STD and the consent given by the victim is not informed consent. So for there to be informed consent in cases of sexually transmitted diseases, the victim has to consent to both the act of intercourse and the risk of contracting a sexually transmitted disease. Now we come back to crimes of violence. Consent will not be a defense to deliberate infliction of harm. In AG's reference number 6 of 1980, the court clearly highlighted that it is not in the public interest that one person would be allowed to inflict harm to the other unless it is clearly for legal reasons. So to say that the victim can consent to harm being inflicted on them will not be an argument. No person can license the other to commit a crime. So if you are deliberately inflicting harm on the other person, you are harming the other person deliberately and they consent to it, their consent will not be a defense and you will still be charged. In the authority of Donovan, 1934, the defendant was charged with indecent assault because what he did was that he had beaten up a girl with a stick for sexual gratification and the girl had consented to it. Although consent was available, but he did not get the defense. Why? because he deliberately inflicted harm, and deliberate infliction of harm cannot be consented to. Similar decisions were reached in Brown and Emmett. Both the cases involved sexual activity involving the infliction of harm on the other partners. In both the cases, although the parties to the cases had consented to the infliction of harm for sexual gratification, but the defense was not available, and consent could not help them get away with what they had done. Because if the purpose of the sexual activity is to inflict harm, it cannot be consented to. However, the rule that deliberate infliction of harm cannot be consented to has certain exceptions. The first exception is surgery, tattooing and body alteration. So if you're getting a surgery done and it's medically prescribed, or even if it's a cosmetic surgery which is considered as something normal according to the standards of your society, that will not amount to um, an offense in crimes of violence, and your consent for the surgery will be a defense. So, for instance, if the doctor is conducting a surgery on you or an operation, they're cutting your body apart for certain medical reasons, and you've consented to it, it will not be a crime of violence, and consent will be a defense here. Apart from that, boxing is a sport where, although the purpose of the activity is to inflict harm, but consent is the defense. There's no clarification as to what is the rationale behind allowing consent as a defense for a sport like boxing, where the aim and purpose is to inflict harm. But to some extent, it is considered to be a sport, which sort of is considered to be something which exists for public interest. Apart from that, games and sports. In games and sports, the courts have been very reluctant to convict the defendant, because when you become a part of the game, the authority of Barnes clearly highlights that by becoming a part of a sport, you impliedly consent to all the risks that may be a part of that sport. So consent will be a defense. So for instance, if you're playing a football match, by agreeing to play the match, you have impliedly consented to all the normal risks. I repeat, the normal risks which are a part and parcel of the game. However, if one football player stabs the other one, that is definitely not a risk which is a part of a game like football. That will be a crime of violence. But as long as it is a risk which is an inherent part which exists inherently when you talk and think about the sport or you play it, then you would be considered to have impliedly accepted the risk. Horseplay is also an exception. In Jones, the defendants were giving birthday bumps to their friend, the victim, and he suffered some really serious injuries. But because it was horseplay and it was an activity which was very normal amongst those friends, court said that horseplay would be an exception to the rule that deliberate infliction of harm cannot be consented to. Then we have another exception, which are sexual relations. Sexual relations, provided sexual relations in which the purpose of the activity is not to inflict harm on the partner. Such sexual relations, if consented to, consent will be a defense in situations harm results. For instance, in the Authority of Slingsby 1995, the defendant and the victim were having consensual intercourse, and the defendant ended up infecting the victim. On the facts of this case, and the victim ultimately died, but the defendant was still not convicted because what he did was not intentional to begin with. The purpose of the activity was not to inflict violence,